He is an ALJ with the OAH. He earned his law degree at the University of California at Berkeley. Why did I say Berkeley? Berkeley, sorry. He is the ALJ who has held all Spanish hearings. He's not a native Spanish speaker. He learned Spanish while teaching English in Chile and from his wife, who is Chilean. Diane Altman serves with the Strategy and Innovation team of the OAH. She's the manager for the Language Access Pilot Project. She has been with OAH for 20 months. Prior to that, she was a certified business coach and securitas management professional. Before that, she owned an insurance business and financial services business for decades. Innovation and change is what she knows best. Judge Josh Sunt is the Deputy Chief ALJ for Strategy and Performance at the Washington State OAH. His more than 10 different functions. I couldn't figure out how he could possibly do all of them. He serves on the agency's pro-equity, anti-racism team. He has extensive experience in various positions as an ALJ. His expertise and knowledge and skills are remarkable. And then we have Brendan Tukey. He will moderate the question and answer session. I didn't catch what he does as an ALJ, and I'm really sorry to say that. I know that he's part of the team that planned this particular CLE, and you all know how good this has been. And he said that he always defers to Michael Schwartz, and that he will do whatever Michael tells him to do. So I don't know who's speaking first, but it's time to start. Thank you.
Thank you, Helen. I will start us off because I'm honored to be the project manager for this project today. What I wanted to say, Division Chief Administrative Law Judge Brendan Tukey is over the unemployment insurance and is perfect for moderating our chat today. So please, let's keep this interactive, that you are welcome to place questions in the chat during the presentation, and at natural pauses, we'll take time to answer that as well as leave time at the end. So we are very aware that you've had a full day. I know you've heard judicial writing and plain talk and unrepresented claimants and being mindful of diversity, equity, and inclusion. We're very honored to be the exclamation point in your day because I believe you've woven these topics throughout this project, and I hope you'll see what I mean as we continue here. Honored to have Chief Administrative Law Judge Lorraine Lee as the executive in Spanish. We'll come back to this in a little bit. I realize in this network with today's conference, you know what the Office of Administrative Hearings does. Like you, our goal is to provide due process and uphold those due process rights. Today, what you will see is the way that we provide that, what it looks like in overcoming language barriers, providing a place where a person can really be heard. So I just want to give you a foundation of why this is happening. In 2019, OAH was one of 4 agencies that participated in the Governor's Results Washington Agency Challenge, where we asked the customers in a focus group of who had participated in hearings, how can OAH support equal access to justice through increased participation in hearings, especially for limited English participants? The answer from the LEP parties in the focus group was unexpected and made OAH pause for a moment. Participants said they found that consecutive interpretation, the standard method of interpreting, going back and forth in what's said, was actually unfamiliar to them, and that it was confusing tracking the ideas for those LEP parties. They felt more interrupted than understood when communicating through an interpreter. So getting this kind of customer feedback promoted OAH to, they prompted us to ask the next question. Is there another way, possibly a better way, for LEP parties to participate meaningfully in the administrative hearing process before OAH. So we decided to explore how we could make a difference. And what you see here is taking that feedback directly from the customer. OAH asked, how could we increase that confidence in the hearing? Is there a way we can decrease barriers in communication? And would speaking directly to the administrative law judge in their primary language make a difference in their understanding and their experience? So our goal became to increase meaningful participation by providing greater accessibility and understanding. So not just showing up for the hearing, which is very important, but participating in their own process. So that came to when you're passionate about something and you believe in something, what do we do about it? Well, we started a pilot project, decided to develop a way to hold certain hearings in Spanish. And as you can guess, it took a lot of people from multiple areas. This project team involved diverse members and stakeholders. Everything from OAH's administrative law judges, legal assistants, customer service specialists, managers, chief administrative law judges, diversity, equity, and inclusion and respect committee, and also partnering with the Employment Security Department, the Commissioner's Review Office, Washington State Immigrant Network. What I want you to take away from this list is not as much the who as how many came together extensively to collaborate and be involved in this pilot project. So the evaluation criteria, we measured the cost, the feasibility, and participant feedback. Some feedback was immediate. We heard things about relief and respect, and the claimant feedback was capturing the essence of the project. So when you see a slide like this that has a colorful banner across the top, you are seeing that we got participant feedback quotes that I wanted to share with you. This person said, I like the manner I was talked to, the judge and I were able to speak to and understand each other well, but what I loved here is it captured the essence of something. It is like a proud thing for me as a Mexican to be able to be understood and to understand using my own language. So how did we do this? There were no existing U.S. processes that we could find to duplicate holding administrative hearings in Spanish. So the project team needed to create a novel approach. Our research showed that the U.S. territory of Puerto Rico is the only American place where we identified administrative hearings are being held in Spanish. As you see from the data, Spanish was a natural place to have an impact. When we looked at the very beginning of this project, 37% of the unemployment insurance hearings where an interpreter was hired needed the Spanish language. So the volume indicated that this was a high access entry point for language access impact. We chose very specific types of cases for this pilot. By focusing on this way, we could be best prepared to serve specialized needs, and we could measure more accurately if claimants had a meaningful experience. So beginning with that collaborative effort, we had work groups that were developed, and we started with communication, quality, and process. And really what I just want to highlight here is communication worked through ideas that would reduce those barriers, creating pieces to communicate what we were doing, including the Diversity, Equity, and Inclusion Committee, Washington Immigrant Network, ALJs and managers. The quality group really looked at vocabulary. You'll see more about that when ALJ Dowdy is presenting, and developed surveys and created spot checks for the quality development process. And then we really dialed into the process the claimant was experiencing by asking, how did they know what to do next and what were the steps were, and then what language is every piece of paper in. And this project has been almost exactly this week, 1 year since the first hearing. And so we also learned that we needed to create processes for contingencies that may come up. So all three work groups came together and collaborated to develop some ALJ scripts that you'll be seeing, presenting feasibility results, held mock hearings to practice with our amazing bilingual customer service team, developed surveys, tracked the data, and then offered recommendations to our executive management. So I just have to ask, and you don't have to put it in the chat or anything, but have you ever received mail that is administrative or legal? Okay, that's not fair since you're adjudicators, but maybe medical mail. How do you know what to do? Is this mail just information? Do you have something that you have to do with it? How do you prepare for something? Where do you find the dates? Now, what if that mail is not in your primary language? Our pilot team really wanted to break down those barriers, and so we took a deep dive into the current process and said, what language is the information provided in, and is it clear, going back to even the plain talk of the English before it's put into Spanish. So real quickly, this is just a map of what that deep dive looked like. I don't expect you to, we're not going to dive ourselves in, but what I want you to notice is the pullouts in the light blue, where the teams really tracked what is happening from one department to another and what language is someone receiving that in. So the boxes aren't the point, the actual people behind the boxes are the point. So we track the claimant's experience of what language do they see their determination letter or make an appeal request, and not just from our own agency, but referring in and also sending out. So as we track that claimant's experience, is there a way that we could make the process leading up to the hearing as clear as possible? Our premise was that going back to clarity and promoting access. Does a claimant know what to do and how to do it? And what are the possible pain points for the LEP claimant in the process? So this is just to illustrate that the process was examined really at a granular level, all the way from the beginning, all the way to if they wanted to file an appeal of their appeal or a petition for review. Another claimant talked about his understanding. One of the things our ALJ did is write a brief note at the end of the hearing about his own evaluation. And one of the notes said that the claimant understood the language. He understood it so well that he felt he was not going to prevail and he wasn't happy, but he understood the hearing. So that's really goal achieved of participating and helping someone understand where they felt they could not otherwise. So OAH created a certification for the Spanish-speaking judges. Listed here, you see the different proficiencies. This is not the same as the Washington State Administrative Office of the Court certification. We found this as an effective way to evaluate based specifically on the project details of the UI hearings and the terms of art as an administrative law judge. So that said, I'm happy to have you hear from the bilingual administrative law judge who's been holding these hearings, ALJ Don Dowie.
All right, thank you, Diane. So let's start a little bit with the nuts and bolts that are involved in holding these hearings. And we're going to start with the terminology here. Now, what we did, our team collaborated with the Employment Security Department to review their 140 glossary terms that they use when communicating with claimants in Spanish. In other words, the terms of art like appeal and benefits and that sort of thing. And we did that to decrease any possible or at least potential confusion when a claimant has already heard a term from the department, but also to have consistency with the department generally and consistency among other judges who may be doing these hearings. So that was the reason for doing that. And we had a nice glossary created that we're able to all share. Now, our team created a variety of scripts incorporating those glossary terms to help us with the different situations and issues in our Spanish-only unemployment benefit hearings. Now, much of this we did prior to the very first Spanish hearing, but we've also continued to modify the scripts as we gain more experience in these hearings. So just winging it, for example, is not really a particularly good option particularly if the Spanish-speaking judge isn't speaking Spanish as a first language. And this is because speaking another language, as you probably can imagine, while also processing incoming information in that language, and at the same time thinking analytically and critically about the information you're receiving, it takes a lot of energy and focus. And the more than conducting a hearing in somebody's own first language. And so what we found was that the scripting really helped us keep the hearings organized and keep them on track. Now, this doesn't mean that the scripts fit every situation or that judges doing the all-Spanish hearings can simply sit back and rely on the scripts to do their hearings. Just like when you create an outline for anything else, you've got to be prepared to depart from that when the circumstances warrant. And it would be really difficult anyway to craft every possible question you might want to ask in the context of a given case. But the scripts are still a great help in providing quality hearings for our participants. Generally, we follow the same paradigm for a hearing in Spanish that we would in English. However, there are some additional things that we do need to do in our all-Spanish hearings that we don't do in our English hearings. We thought that might be interesting for you to hear. So we're going to highlight some of these going forward. So what you see here is a portion of a script for opening a hearing. Spanish on the left, English on the right. Now, although it might seem obvious, one of the first things that we want to confirm is that the claimant is fluent in Spanish, and other participants if there are other participants in the hearing. We sometimes get, on occasion, claimants from Latin America who don't speak Spanish well, even if they're living in Spanish-speaking countries. Mixteco is one such language. Some of you may have run into that. It's a mix of Spanish and pre-existing languages that date to before the arrival of the Europeans. And once in a while, we accidentally get somebody assigned to a case who doesn't speak Spanish at all and maybe lives somewhere else entirely. So we have to be sure on the record at the very outset that the claimant or any other participants, if any, are fluent. Now, you're also going to note here, we have a contingency set up in the event that anyone else is attending. And that's just to remind us, okay, we've got to check in with them as well. Now, in addition to what you see here, we're also developing some scripts for the contingency where we may have Spanish-speaking attorneys representing a claimant. And our hope going forward is that we may be able to hold those hearings as well. But that's a work in process at present. Now, one of the most important things that we also do early in the hearing is to tell people that they can request an interpreter at any time. Now, they don't often do that, but obviously it needs to be an option for due process purposes. Yeah, here's an example of one of those scripts, again, with Spanish on the left and English on the right. I may have gotten that backwards last time, but I'm sure you recognize the difference. As you can see, the judge empowers the participants. They have the choice at any time during that hearing to continue the hearing with an interpreter if they want. They don't have to give a reason. It's simply whatever they choose. We also disclose if the judge's first language is not Spanish. So I always tell participants up front that Spanish isn't my first language. I think as you heard at the start, I learned it from Chile. I learned my Spanish in Chile and from my wife. We do speak it every day, but participants need to know. They need full disclosure so they can make an intelligent, knowing decision as to whether they do want an interpreter. And so we do our best to make sure that's all on the table starting out. Now, the judge can also make the decision to pause the hearing and seek an interpreter. And again, I haven't had to do that very often, but it has happened. Times when I just could not understand the claimant and I had to stop the hearing. This is actually a really important point I do want to highlight for a moment, and that is knowing when to stop the hearing and reschedule with an interpreter. You know, we obviously would never do it if we had a choice, but sometimes you have to. And that's one of the things I've improved on quite a bit. Now, when I first started, I had a few hearings where I thought I was understanding somebody fine, and then we started getting into the nuts and bolts of the testimony, and I realized, you know what, this isn't a good idea. And I think it happened once or twice, and I stopped the hearing and we rescheduled with an interpreter. But that's one thing I've improved on quite a bit now. I can usually tell in 3 minutes if I'm going to have any problem understanding somebody. And obviously then we take the appropriate steps. Again, it doesn't happen often, but it's something that we've got to be on our toes about all the time. Now that takes us to our next important point.
Don, I'm going to interject. We had a question: is Spanish the only other language available for the litigant? And are there other languages that are available to the litigant in hearing? Right now, it's only Spanish. We're still in the pilot project. The long-term hope would be that we would have opportunities to add other languages. Of course, a big limiting factor is what are the language skills that the judges that we have, what are the skills and what are our resources. But right now, just Spanish, but hopefully in the future, we'll be able to expand the scope of this project. Thanks, Don.
Oh, you bet. Pardon me. All right. So the next important thing that we do is to establish understanding on the record, confirm understanding with all participants. So we test for understanding early in the hearing as well, before we cover any statement of legal issues, certainly before we get into any evidence. And so that what happens is the ALJ asks participants, if you have more than one, we ask them in turn, simple questions. These are just designed to see if the ALJ understands them and just to confirm that they understand the ALJ. We tell them in advance their answers have no bearing on the outcome of the case, and that's just so that we can focus on the confirmation. So we have to ask questions that don't matter. For example, we ask about favorite foods, about pets, about weather. We do stay away from things like people's jobs and what kind of automobile they have, because things like jobs and transportation can be relevant to the issues in an unemployment case. So once we've done that, we confirm, if we're able to, on the record, that each participant understands us, the ALJ, and that we understand them, and that the case is fit to go forward. Obviously, if you can't make that finding, you have to bring an interpreter in to serve. But in doing this, one of the other important things to keep in mind is that the sole reason for doing this is to confirm understanding. We've got to be really careful. We're not sending a message that we're empathizing with our participants, that we're anything other than neutral. So if somebody says, oh, I love spaghetti, we can't jump in and say, oh, yeah, me too, it's my favorite. We just have to either, I understand, or just ask the next question. So that's one of those things we have to keep an eye on there. And it's not the end of checking for understanding. We do it throughout the hearing, but this is a very key part of the whole process. Okay, let's go on here. So the proof is in the pudding, as they say, and so far, I think our team is very pleased with the way the pudding is turning out. The vast majority of comments we've received from our Spanish-speaking participants has been very positive, and you can see the one here actually is fairly typical. People appreciate the opportunity to communicate in their own language and to feel like they've been heard in their own language by the decision maker directly. Now, as you can see from the excerpt here, using an interpreter can add an additional layer to the process, and it can detract from the hearing's efficacy. We've also had claimants who understand English who have used interpreters in other contexts say that they don't always think the interpreters necessarily get it right. And so they really do like, in most cases, they feel very confident about having a judge who can communicate with them directly. And I would frankly rather hold a hearing in Spanish most of the time than use an interpreter. Now, obviously, there are times when we have to have interpreters. That's just part of the deal. But as we can see here, this is another option. So while this project is a work in progress, we do feel like the pudding that we've prepared up to now is quite fit for the table.
Thank you, Don. I'm just going to show you some of the pilot results from phase 1. The original pilot ran for 3.5 months from November to February. We scheduled 77 hearings, and you can see the breakdown here of what those looked like. We had 42 hearings held at the end of phase 1. So when the claimant disagreed with the appeal and wanted to appeal to the Commissioner's Review Office, then we needed to have that record in English for the CRO to review. So we had an audio recording of the hearing that was in Spanish, and we had it interpreted into English for the Commissioner's Review Office. The cost for that recorded oral interpretation was $190, and that was the only direct new cost for the program.
And DJ, we had a question pop in. Do we have stats for comparable percentage for hearings in English? We do. We know that a single party unemployment insurance hearings without overpayments have very high default rates in excess of 50%. We know that all of our case types put together, every variety we have in English, typically have a default rate of around, in any given year, 35 to 38% or so. And so we see that the default rate in the Spanish language hearings is quite a bit below what we normally see in single party hearings. The inference we're drawing from that is that, those parties receive a lot of outreach in Spanish from our bilingual call center to prepare them for the hearing and to make sure they're aware of their hearing date and that their hearing is going to be in Spanish. And then we also infer that knowing that the language, that the hearing will be in their own language, further enhances the response rate. Thanks, DJ.
Thank you, Brendan. Hey, great question, Sarah. Appreciate it. Analysis of that phase 1 data shows that there are both new costs and cost savings, and the results indicate that there could be an overall cost savings. So likely this is a project that is also good stewardship for taxpayer money. There were also approximate time savings. The average time it took during the pilot for a Spanish hearing was 48 minutes. And when an interpreter is used, 2 hours are scheduled. So the time savings was appreciated not only by in the 42 hearings held, it saved approximately 50 hours of the ALJ's time. But we found that the claimant also appreciated the time savings. And you can see here, they're saying that with an interpreter, many things are repeated. With the hearing in Spanish, it was fast, concise, and I liked it much better than it was without an interpreter. So where did we get all this feedback? We wouldn't want claimants to think they could sway the outcome by giving rave reviews. So they knew the judge wouldn't see their responses connected to them. And our bilingual service team that Brendan referred to called them after the hearing, but before they received their order. So these were oral over the phone. There were 5 questions that were asked, and they were asked in Spanish as well. And they had that explanation that it would not impact the judge's decision. So when we did the surveys, we looked at that, the meaningful participation, the understanding, and the accessibility. And we had them on a scale of 1 to 10, so we could get feedback that we could really look at the data analysis, but we also asked them open-ended questions about feeling like they had participation in the hearing, and did they feel completely understood. And so the feedback you've seen is not lead, it is their direct communication with our bilingual team. So these results are fantastic. 97% rated their experience as excellent or good, and the results are based on, for this phase, 29 hearing surveys. But by talking directly with the claimant on the phone in that survey format, the bilingual team was able to really hear their story and document their answers. Meaningful participation really came through. One claimant said, you know, while we feel great about the significance of the feedback, they said, I felt as an active participant. And the judge helped me feel good. There was a time when I told the judge my story, what my family and I were enduring, and he listened to me. So let's hear from Deputy Chief Administrative Law Judge Josh Sunt about the legal significance of this project.
Thanks, Diane, and good afternoon, everyone. It's an honor to join with my colleagues to be able to talk with you all about our Spanish unemployment insurance hearings project this afternoon, especially on the last presentation at the end of such a wonderful conference. I've learned a lot of stuff here myself today. In fact, I'm taking a cue. I want to take a cue from Brian Watkins' great presentation this morning and his advice about front-loading the information. And it got me to thinking about my slides in this presentation and, you know, how would I boil them down. So I did that, and all of my slides comes down to basically three things. Language access is really important. There's no one formula for delivering it successfully, and we have to be flexible and innovative in figuring out how to best deliver language access. So that's it. That's my message. You can go early if you want, but if you want CLE credits, you probably have to stay till the end of the presentation. So to get into that a little bit, for those who do want to stick around for the details on that, you know, why is it important? Well, one reason is the U.S. population and Washington State's population. The LEP population has grown really quickly nationwide between 1980 and 2010. I'll show a slide in a moment on that. Washington's population of people with LEP is large, I would say, and growing. It has stabilized a little bit since around 2010, but you can see it's still growing. In 2014, LEP residents were 9% of the Washington State population, and as of the Office of Financial Management's estimates in 2021, that grew to about 9.4%. Spanish alone, 6.2% of the population, according to OFM's estimate, almost 500,000 people with Spanish-speaking LEP. That's a lot. That is a huge percentage of the people that we serve. Here's data from the, oh, sorry, Diane. I needed to give you a moment there to advance the slide. No, thank you for advancing. Slide advance was perfect timing. I just realized I didn't give you enough time. So this is from a 2016 Department of Justice report on language access in state courts, and it's just demographic research nationwide, showing that really the LEP population in the U.S. more than doubled from 1980 to 2010. It has, like in Washington, it has sort of leveled off a little bit more after that point, but it continues to be large, and it still is continuing to grow. So in doing some research about when I got this assignment from my director, who many of you know, Chief Administrative Law Judge Lorraine Lee, to help understand the legal significance of this project that we were doing and the legal underpinnings. As I began to dig into this and do this research, I began to see a lot of patterns in terms of the statements that the ABA would make, that the Department of Justice would make, that various commentators and judges would make about language access. And this is a little collection of some of those themes that I saw. So notions of fairness, notions that people should be able to follow the legal proceeding in a language they can understand. That's from an international tribunal. Equal treatment, equal access to courts. We understand equal protection. Due process is something we think about all the time as judges. Civil rights and non-discrimination. And then even larger maybe, what about the integrity and the public confidence in the justice system? So these were themes that I saw throughout that research. So what's the actual law on language access? I've summarized some of it here. Obviously, this is not intended to be a presentation on language access law, but more the legal implications of this project that we are diving into. But there's some interesting points. The Constitution, apparently, so far, cases to date, offers language access protection for criminal defendants. There have been cases on that. But there haven't been cases at holding on a constitutional, as a point of constitutional law, that in civil cases or administrative law cases, there is protection in terms of language access. There have been cases on holding that the Civil Rights Act of 1964 provides support for language access requirement for programs or activities receiving federal financial assistance. And that's the Lau v. Nichols case. The Lau v. Nichols case was a case where, well, it was back in, I think, 1971 when the San Francisco School District integrated. There were about 2,800 students of Chinese ancestry who had LEP, and we're not able to get the educational benefits from the instruction that was provided, and so about 1,000 of them did get some help in terms of English as a second language, some supplemental instruction in English, but that left about 1,800 who didn't have anything. They didn't understand English. They were going to school in English, and that resulted in this lawsuit being filed, and the U.S. Supreme Court held in a unanimous decision that the Civil Rights Act did protect these students, and that they were required to have meaningful access to the advantages and disadvantages of the advantages provided by the school system. Interestingly, the Ninth Circuit, the court below, before it went to the Supreme Court, had found differently. They had basically a sink or swim theory. So their reasoning was basically that every student brings to the starting line of his educational career different advantages and disadvantages caused in part by social, economic, and cultural background, created and continued completely apart from any contribution by the school system, unquote. So sink or swim, right? The Supreme Court pretty vehemently disagreed with that, and basically held that if you're providing instruction in English, what should seem obvious, if you're providing instruction in English to students who don't understand it, they're effectively foreclosed from any meaningful education. The Supreme Court said basic English skills are at the very core of what these public schools teach. Imposition of a requirement that before a child can effectively participate in the educational program, he must already have acquired those basic skills is to make a mockery of public education. So that was Lau v. Nichols. That caused a lot of activity in the language access world. There was a Equal Educational Opportunity Act of 1974, very shortly after the Lau decision came down. There were the Lau remedies, which were created by a federal agency trying to design guidance for how the language access should be provided. So this ruling had a big impact, which continues to this day. There are also the Department of Justice regulations. So the Department of Justice provides financial assistance to various courts, and then they also have this unique role where they're also giving guidance to those other federal agencies who are providing federal money for various programs, so including unemployment insurance. And so the Department of Justice has been a big player in terms of providing policy guidance. And then there are the various federal agencies like the Department of Labor or Health and Human Services, those departments have their own regulations, often very closely modeled after the Department of Justice regulations. In Washington State, it's similar, but it's different. We have our law against discrimination, so our analog to the 1964 Civil Rights Act, the Washington Law of Discrimination, that protects against discrimination based on national origin, citizenship status, immigration status. National origin by the terms of the act includes ancestry. There are other categories, but these are the ones, some that I picked out relevant to language access. There's also the intent statement in Chapter 243 in the RCW. It is declared to be the policy of this state to secure the rights, and this is interesting, constitutional or otherwise, of persons who, because of non-English speaking cultural background, are unable to readily understand or communicate in the English language and who consequently cannot be fully protected in the legal proceedings unless qualified interpreters are available to assist them. And I'm interested by that constitutional or otherwise because I didn't mention this, but in the Lau v. Nichols case, equal protection claim was brought. So the plaintiff did argue that under the Equal Protection Clause of the U.S. Constitution, they should be provided this language access. The Supreme Court, interestingly, did not make that ruling. So they ruled on the more narrow ruling that the statute controlled and required language access services. I'll get to the other piece about that in a moment. And then we have a statute for public assistance benefits. This applies to OAH. It applies to the Healthcare Authority. It applies to the Department of Social and Health Services. That's RCW 7404025. That does a number of things. It requires the agencies to provide bilingual services. And it's interesting that it doesn't define all of what those services are, but it says they shall be provided to the extent necessary to assure that non-English speaking persons are not denied or are unable to obtain or maintain services or benefits because of their inability to provide or to speak English. How does the language access, the legal requirements for language access, how do they apply in the administrative law setting? Well, I already mentioned the Washington Law Against Discrimination. So that applies to our administrative proceedings. But Chapter 243 in the RCW has an explicit definition. It explicitly brings in administrative boards, commissions, agencies, or licensing bodies of the state or any political subdivision thereof. So it does control in a legal proceeding that is in an administrative law context all the requirements of Chapter 243. And then, of course, a lot of the benefits that we're talking about when we're talking about administrative law, a lot of the programs do have some sort of federal financial assistance. And if the agency is a recipient of that federal financial assistance, then the DOJ in there, this is actually in a footnote in some policy guidance, but the DOJ would include those administrative adjudication systems in the definition of courts. So basically in all of the guidance that they have provided, they're thinking about us too. So I've kind of touched on this a little bit, but in reading these different cases, it's interesting that there really aren't a lot of prescriptive remedies. Like, oh, well, this is the solution. Provide an interpreter, or provide instruction in English as a second language in the educational context. The Supreme Court really focused in Lau v. Nichols, really focused on the meaningful opportunity to participate. Sort of vague in its appropriate remedies language, not going to figure it out at that level. And then the DOJ has been working on this for years. And even those very detailed standards really focus on this meaningful opportunity to engage and participate it's about ensuring meaningful access, and the stress is on, well, it's got to be flexible. It's got to be fact dependent. There's a 4-factor analysis, but that's looking at different programs and different populations, and doing the analysis on a case-by-case basis. So, and looking at your available resources, looking at how many speakers there are of a certain language, or what the specific need is. So there's a real call to be looking creatively at the solutions. And Diane, if you can go to the next slide, I think that's the next point I just want to make. The Department of Justice really encourages agencies and organizations to share resources on language access, be creative in thinking about this, how to best serve the populations with LEP. When particular languages are encountered often, hiring bilingual staff offers one of the best and often most economical options. I know Diane mentioned the economy potential in this. That's the DOJ's take on this as well. And then the ABA has commented in their report on the language access standards for state courts that hiring bilingual staff can be a particularly effective way to provide that language access. Here's the head of the Civil Rights Division with the U.S. Department of Justice. And you can just see this is in a cover letter to a report on language access in the state courts. And you can see there's the call. Again, we've got evolving demographics. We have to modernize. We have to keep pace. We have to innovate. We have to adapt, be flexible. I mean, that's the takeaway. There's not a one-size-fits-all prescriptive solution. So the impacts, also in looking at the cases, looking at the commentary on the cases, and reading the material from the DOJ and the ABA, there's a lot of commentary on what the impacts of effective language access are, or actually more commonly what the impacts of poor language access is. And I won't read through this list, but it can impact the accuracy of the records. It can certainly strengthen the as you've seen from some of the quotes, it can strengthen the feeling of the participants that they are truly engaging with the process and that they are truly being heard. And I think I like to sort of close out my slides with just this a last quote, which is an even bigger reason. The vibrancy of our democracy depends upon our willingness to ensure that the fullest range of voices and interests is represented and heard. This is what the fight for equal justice is all about. That's from the late Washington State Supreme Court Justice Robert Utter. So Diane, I think I'll turn it back to you, unless there are questions for me, which I'm happy to take.
I saw a comment. I'm not sure it was a question.
I think it has a little bit of both. So from Dave Swan, a wonderful and fascinating undertaking and program. I think I noticed that for now it's limited to single LEP Spanish-speaking litigant. That's true. If an English-only employer wishes to observe, do you have a means or planning means for that to occur? Do you or will you provide an interpreter for them? So where we have non-Spanish speaking observers or participants, such as a witness or an attorney, we go ahead and we conduct the hearing using an interpreter. One of the areas, though, in which we want to expand is to, and right now we limit the program to non-representative claimants. So as we look to expand the program in the future, we'd like to be able to add where there's an attorney who's a Spanish-speaking attorney who might be able to be there, and to be able to add more complexity and nuance to it. Don, did I capture that accurately?
Yes, I can improve on it.
Well, as you look at this project timelining, we're not going to get into a granular level. Really what I want to point out is that project initiation. The first ever Spanish administrative law hearing was held November 2nd last year. So it's it's exciting that as we move forward, and the work groups were formed. There's a pilot, data, analysis, recommendations, presentations, and so the project team made the recommendations and to continue the groundbreaking work and adopt the practice of holding hearings in Spanish as a regular part of the OAH processes. So where are we now? We've started phase 2 with our goal of holding 58 more hearings so that we can evaluate 100 total hearings held. Today, we've currently completed 40 hearings during phase 2, and that's accurate today information, just checked this morning. So we have 18 more hearings until we have 100 held in Spanish to have a great opportunity to evaluate at a larger number. We're also adding another bilingual administrative law judge who earned the OAH proficiency certification this month.
And DJ, I'll go ahead and interject now. Carl asks, does the Unemployment Law Project have any Spanish-speaking attorneys available? And I do not actually know the answer to that question. I don't know if any of our participants might know, but I do not know the answer to that question off the top of my head, Carl.
We are in good communication with them, and that's also one of the contingencies we have planned for as they bring that forward. And you saw in Don Dowie's scripts that there's that opportunity for someone to be represented with a Spanish-speaking representative. So that communication is open, and they're very aware of this project and have had input along the way. This quote, I've given you a little more time to look at because this was just from last month. So the feedback has continued to be solid, that people are feeling heard and understood. And this I highlighted, I was able to express what I wanted. So we're full circle to the agency design challenge where we heard that people had felt interrupted. The people participating in this pilot are giving us the feedback that they are feeling heard and understood. From phase 2 last month, also this feedback continued to show the nuance of respect. I appreciate the support to the Hispanic community. This experience gave me a variety of options, and for someone like me that speaks a little English, it helped me express with more assurance and understand without a doubt. I just think that is so powerful that those nuances are coming through. And just last week, actually, someone is saying, I felt completely understood by the judge. It was helpful to have the hearing in Spanish. I felt important during the hearing because the judge listened to what I had to say. And so as we presented this project, I hope that you've seen the long-term pieces from the data. You've caught a glimpse of the hearing experience as the ALJ was talking about how he operates those. You gained insight on the legal significance in working with those overcoming barriers. And so if I was going to dial it down like Josh did and like a previous speaker said, I would say that this is a groundbreaking pilot with significant results. And it was a collaborative and continues to be a collaborative effort that is producing meaningful participation and access to justice. So I want to honor our executive project sponsor, who you know, Chief Administrative Law Judge at OAH. Without her leadership and passion and ability to provide tough and thoughtful decisions throughout this project, I don't think it would be where it is today. It's an honor to get to manage this project, and you'll see here, it's a continuation of the quote that I shared earlier that she says, this innovative approach is a new tool for promoting equitable access for all parties in OAH hearings. So here are a few of the resources used for today's materials, but also if you're interested in more, you can email us. You've heard from the people who are resources, and we can send you a 2-page resource overview or continue the conversation. So you're welcome to continue the conversation as I turn our time over to Division Chief Administrative Law Judge Brendan Tukey for any questions or comments.
Yes, so far we've been taking kind of questions as they come in the chat, but we do want to invite anybody that has a question to just come off mute and throw your question out there, or if you have a comment or suggestion, those are welcome as well.